The letter arrived at a Montana rancher's door on a Wednesday afternoon. Not from his bank, not from his county assessor, not from any of the ordinary institutions that send letters to people who own land in rural America. From a legal organization he had never heard of, claiming an interest in property his family had owned for 3 generations, citing a legal doctrine he had never encountered, and informing him that unless he responded within 30 days, proceedings would move forward without him. He was not alone. Across the country, from the forests of the Pacific Northwest to the farmlands of the Great Plains to the coastal properties of the Southeast, similar letters were landing in similar mailboxes. Property owners who had purchased their land legally, paid their taxes faithfully, maintained their properties responsibly, suddenly finding themselves named in legal proceedings built on a doctrine that most of them had never heard of until the moment it was being used against them. That doctrine is called Aboriginal Title, and until this week, it represented one of the most legally uncertain and practically threatening clouds that could hang over privately owned land in America. Aboriginal title is a legal concept rooted in the idea that indigenous peoples who occupied land before the establishment of the United States, government retained certain legal interests in that land that were never fully extinguished through the treaty process or through subsequent transfers of ownership. In its most aggressive legal applications, Aboriginal title claims argued that current private landowners, regardless of how many times their property had been legally bought and sold, regardless of how long their families had held title, regardless of every tax payment and deed recording and legal transaction in the property's documented history, could still face legal challenges to their ownership based on historical indigenous occupancy that predated all of it. The legal threat this created for landowners was not theoretical. Cases had been working through the federal court system for years. Some had produced rulings that sent genuine shockwaves through property rights communities. Some had resulted in outcomes that forced settlements, complicated sales, clouded titles, and in some cases directly affected the ability of landowners to use, develop, or transfer property they had every reason to believe they owned completely and securely. The Supreme Court of the United States just refused to hear an Aboriginal title appeal. And that refusal, that single procedural decision by the highest court in the land, has produced an outcome that property rights attorneys are tonight calling one of the most significant victories for private landowners in a generation. Not because the court issued a sweeping new ruling, but because of what its refusal to act means for the lower court decision that was being appealed, and what that decision means for every. To understand why the Supreme Court's refusal matters so much, you have to understand what it left standing. When the Supreme Court declines to hear an appeal, the decision of the lower court becomes the controlling legal authority in that jurisdiction. It stands, it applies. It shapes how courts in that jurisdiction handle similar cases going forward. And in this specific case, the lower court decision that just became controlling authority is one that property rights attorneys have been watching with intense interest since the moment it was issued. The federal appellate court, whose decision the Supreme Court just allowed to stand, ruled in a way that significantly narrowed the circumstances under which Aboriginal title claims can be used to challenge the property rights of current private landowners. The ruling established specific requirements that Aboriginal title claimants must meet before their legal challenge can proceed. Requirements that are grounded in historical documentation, in the continuity of occupancy claims, and in the relationship between those claims and the specific legal history of how the land in question passed from one owner to another over time. Those requirements matter enormously for practical reasons. Before this ruling, the legal standard for bringing an Aboriginal title claim was uncertain enough that challenges could be initiated with relatively limited documentation of historical occupancy. The burden of responding to those challenges fell heavily on current landowners, who had to defend titles they purchased in good faith against claims rooted in historical circumstances they had no part in creating, and no way to have anticipated when they bought their property. The appellate court's ruling, now left standing by the Supreme Court's refusal to hear the appeal, shifts that burden. It requires claimants to establish specific historical documentation of continuous occupancy before a challenge can proceed to the point where current landowners are required to defend their titles in court. It raises the threshold for what constitutes a legally viable Aboriginal title claim in ways that protect good faith purchasers who acquired their property through legitimate legal processes. For the Montana rancher who received that letter, for the farming families across the Midwest who have been watching Aboriginal title litigation with growing anxiety, for the residential property owners in the Pacific Northwest whose titles have been clouded by pending claims. For all of them, the practical consequence of the Supreme Court's decision this week is that the legal framework surrounding their ownership just became significantly more stable, not perfectly stable, not immune from all future challenge. Property law in America is never entirely free of complexity in the legal landscape around. Indigenous land rights remains an active and evolving area of law that will continue to generate litigation and court decisions for years. The phone calls started before the Supreme Court's decision had been public for 6 hours. Property rights attorneys across the country fielding calls from landowners who had been living under the shadow of pending Aboriginal title claims for months or in some cases years. Landowners who had been advised by their own attorneys to wait, to monitor developments in the federal courts, to avoid making major decisions about their property until the legal landscape became clearer. The landscape just became clearer. And the calls coming into those law offices today reflect the immediate practical relief that a significant portion of the landowner community is feeling in the wake of the Supreme Court's decision to leave the appellate ruling standing. But the picture is not uniformly simple, and responsible coverage of this development requires saying clearly what the decision does and what it does not do. Because the gap between those two things is where misunderstanding creates its own problems for landowners who respond to legal developments without fully understanding their scope. Here is what the decision does. It establishes a higher evidentiary threshold for Aboriginal title. Claims proceeding in federal courts within the jurisdiction of the appellate court whose ruling now stands. It requires documentation of continuous historical occupancy that meets a specific legal standard before a claim can advance to the point of directly threatening a current landowner's title. It creates a more defined legal framework that both claimants and landowners can use to assess the viability of specific claims before expensive and disruptive litigation consumes years of both parties' resources. For landowners in states within that appellate jurisdiction, the practical effect is significant and immediate. Pending claims that cannot meet the new evidentiary threshold are now legally vulnerable to dismissal. New claims that might have been filed under the old lower threshold face a much harder legal road. Title insurance companies operating in affected states are already reviewing their policies and their risk assessments in light of the changed legal standard. Here is what the decision does not do. It does not eliminate Aboriginal title as a legal doctrine. Indigenous land rights claims remain a legitimate and constitutionally recognized area of American law. The Supreme Court has never suggested that historical Indigenous interests in land are legally irrelevant. The decision that now stands as controlling authority addresses the evidentiary standard for pursuing those claims. It does not erase the underlying legal rights that generate them. It does not apply uniformly to every federal jurisdiction in the country. Different appellate circuits have jurisdiction over different states. The ruling that the Supreme Court left standing controls in its specific circuit. Landowners in other circuits are subject to the legal standards their own appellate. That Montana rancher who received the letter on a Wednesday afternoon, who spent months consulting attorneys and reviewing documents and lying awake wondering whether everything his family had built on that land was legally secure, woke up this week to a different reality than the one he went to sleep in for the past 2 years. Not a perfect reality, not a world where every legal question about his property is permanently and completely resolved, but a reality where the specific legal threat that letter represented has been significantly weakened by a Supreme Court decision that he had no part in making, but that affects his life in ways that are immediate and real and deeply personal. That is what property rights victories look like in practice. Not dramatic courtroom moments, not sweeping declarations that resolve every complexity in a single ruling. Incremental, hard-fought, technical legal developments that accumulate over time into a framework that either protects ordinary people or fails them. This week's development protects them, meaningfully. And every landowner in America should understand specifically how. The Supreme Court's refusal to hear the Aboriginal title appeal sends a message that travels further than the specific case it resolves. It tells lower courts, state and federal, that the more protective evidentiary standard for Aboriginal title claims is legally sound enough that the highest court in the land saw no reason to disturb it. That signal shapes how judges across the country approach similar cases even in jurisdictions not directly controlled by the appellate ruling that was left standing. It tells title insurance companies that the legal framework around private land ownership is more stable than it appeared 18 months ago, when the most aggressive Aboriginal title litigation was generating outcomes that made underwriters genuinely nervous about properties in affected regions. It tells real estate markets in affected areas that transactions which had been complicated by title uncertainty can move forward with greater confidence. Properties that had been difficult to sell or finance because of clouded titles have a clearer legal path to resolution. And it tells the landowners who have been receiving Letters like the one that arrived at that Montana ranch that the legal system has not abandoned them, that the courts are capable of drawing lines that protect good faith property ownership while still operating within a legal framework that takes historical land rights seriously. None of this means the fight is over. Aboriginal title litigation will continue. Indigenous land rights claims will continue to be filed and argued and decided in courts across the country. The legal landscape around these issues will keep evolving. New cases will generate new precedents. New arguments will test the boundaries of the framework. This week's decision reinforced